Thanks, Deputy Speaker. I also rise to speak in support of the Treasury Laws Amendment 2023 Law Improvement Package Bill 2023, and I commend earlier contributions to this debate and also look forward to the contribution of the member for Bennelong in the next bill coming up for debate. Deputy Speaker, the Albanese government, as part of its regulatory stewardship role, a role that we take incredibly seriously, is progressing amendments to ensure that Treasury portfolio legislation remains current and fit for purpose. The amendments to this bill, as many speakers have said, are mostly technical and will reduce complexity in Australia's corporations and financial services law, increasing its navigability and enhancing its clarity, all important aims. Deputy Speaker, I'd also like to thank the hard work from the Assistant Treasurer in relation to bringing this bill to Parliament, his team, and the incredible hard-working public servants that have worked to identify these changes and implement these changes to reduce red tape for businesses and consumers. Deputy Speaker, yesterday I spoke about the importance of expertise in public service, and the comments that I made yesterday equally apply to the detailed work that goes into making sure that recommendations from reviews are able to properly take effect in legislation such as this. But Deputy Speaker, for some context, and particularly in relation to the changes proposed in Schedule 1, in September 2020, the then Attorney-General asked the Australian Law Reform Commission to inquire into the potential simplification of laws regulating Australian corporations and financial services as part of the government's response to the 2019 Royal Commission into misconduct in the banking, superannuation and financial services industry. The AORC found, unsurprisingly, that the law is challenging to navigate and complex for individuals and businesses, and that it needed to be simplified to ensure its intent is met. Additionally, the AORC's Interim Report A focused on the use of definitions. It found that complexity could be reduced by only using defined terms where this reduces repetition and enhances readability, improving the design of definitions and using defined terms consistently throughout the corporations law. Deputy Speaker, the AORC made 13 recommendations along with 24 proposals and questions for further consideration. The recommendations primarily addressed unnecessary complexity in the corporations and financial services law, as I said. They unfreeze the AIA, create a single glossary of terms, remove redundant definitions and make other simplifications. Deputy Speaker, the AORC review effectively called for some spring cleaning to be done to make it easier for business to operate. And while it may only be winter, the government is getting on with the job of implementing these recommendations. So, Deputy Speaker, as I said earlier, Schedules 1 to 3 to the bill implement recommendations that were identified by the AORC in interim reports A and B from the AORC review. This includes the unfreezing the application of the AIA to the Corporations Act and the ASIC Act, creating a single glossary for all defined terms in the Corporations Act, repealing redundant definitions, addressing unclear or incorrect provisions, and simplifying unnecessarily complex provisions in the law. Schedules 1 to 3 will improve that navigability and simplify the law by improving clarity with a particular focus on terms defined as having more than one meaning and definitions containing substantive obligations. Correcting errors, as the member for Bennelong said, despite best intentions, there are errors that do occur in our legislation. It's important to do that spring clean, and of course by repealing redundant definitions. The consequence of these changes in Schedules 1 to 3 will facilitate a more adaptive, efficient and navigable legislative framework which ensures that the legislative intent is actually met. Deputy Speaker, Schedule 4 to the bill creates amendments to the Insurance Acquisitions and Takeovers Act of 1991, Life Insurance Act 1995 and the Insurance Act 1973. Those acts are the enabling acts of certain legislative instruments regulating the insurance industry that are currently due to sunset on the 1st of October 2023, not that far away. Deputy Speaker, as the member for Fraser talked about earlier, sunsetting is the automatic repeal of legislative instruments after a certain date unless action is taken to retain them. Sunsetting is important to ensure that legislative instruments are kept up to date and only remain in force so long as they are needed. The purpose of the relevant insurance acts is to protect policyholders by regulating the types of persons that may carry on insurance businesses and prescribe standards to ensure the prudent management of the insurance industry. Deputy Speaker, the amendments will help to ensure that the sunsetting insurance instruments do actually come up to date and are fit for purpose when they are remade. So, as speakers have said, they are primarily technical, but they include updating certain provisions to reflect modern communication practices, where I do note your important contribution on the relevance of fax machines still in some enterprises, to allow regulators to administratively prescribe the manner and form of certain notices to increase flexibility and align with modern drafting practices, and moving some provisions in the insurance instruments into the primary legislation. Essentially, these amendments to the enabling acts of certain legislative instruments will help to ensure that, as I said, that they'll remain up to date and fit for purpose when they're remade. Primarily technical in nature, but still critical that they be made. Deputy Speaker, changes proposed in Schedule 5, rationalisation of ending ASIC instruments. Well, Deputy Speaker, class orders and legislative instruments that notionally amend the primary law or regulations may cause complexity in the law and undermine accessibility. This can make it difficult for entities to identify and understand the law as it applies to them. Schedule 5 to the bill moves these notional amendments into primary law and regulations to provide greater certainty and clarity of the law and make it easier for industry and consumers to navigate Treasury laws. So to achieve this, Schedule 5 to the bill amends the Corporations Act and the National Consumer Credit Protection Act 2009 to incorporate long-standing matters currently contained in the Australian Securities and Investments Commission legislation. Long-term reliance on ASIC's exemption and modification powers to update the law for changing circumstances makes it difficult for regulated entities to understand the full state of the law as it applies to them. So amendments in Schedule 5 to the bill will improve the clarity of the law, provide certainty and make it simpler for regulated entities and consumers to properly understand their rights and obligations. Deputy Speaker, as the Assistant Treasurer made clear in his second reading of this bill, for a long time ASIC relied on its exemption and modification powers under the Enabling Acts to update the law for changing circumstances. But this is a more appropriate approach by moving the operation of those legislative instruments into the primary law. This provides, as I said, greater clarity and certainty and is actually a much better approach for consumers to properly understand their rights and obligations. Deputy Speaker, moving on to Schedule 6, there is an ongoing need to make technical amendments and corrections to Treasury portfolio legislation at times just to rectify minor problems with the law that prevent it from operating as intended. The minor and technical amendment process in this schedule is consistent with the recommendation from the Tax Design Review Panel in 2008. This panel was appointed to examine how to reduce delays in the enactment of tax legislation and improve the quality of tax law changes. It has since been expanded to all Treasury portfolio legislation. The panel identified a requirement that appropriate priority should be given to the ongoing care and maintenance of the taxation system. The regular minor and technical amendments process has since been expanded to cover all Treasury portfolio laws. So this schedule makes minor and technical amendments to those laws to make sure that they do appropriately operate in accordance with policy intent. Some minor changes are also made to improve administrative outcomes, remedy unintended consequences and correct technical or drafting defects. The amendments have been identified by Treasury, portfolio agencies and the Office of Parliamentary Counsel. Deputy Speaker, again, I'd like to thank the Assistant Treasurer and his team and the public servants who've done so much work in this dry but important area for all the work that they have done on this legislation. This legislation again reflects the hard work that the Albanese government is prepared to do to make sure that business is easier to do here in Australia. Those opposite have often talked about the need to continue to reduce red tape in Australia and make business easier in this country. Since the election of the Albanese government, doing business in this country continues to become easier and was a focus of our last budget. Deputy Speaker, we're progressing these amendments to ensure that Treasury portfolio legislation remains current and fit for purpose. The amendments in this bill are mostly technical and will reduce complexity in Australia's corporations and financial services law, increase its navigability and enhance its clarity. I welcome the support of those opposite and some of their positive contributions that they have made to this debate. And again, I'd like to thank the hard work from the Assistant Treasurer and the incredible hard-working public servants that have worked to identify these changes to reduce red tape for business and consumers. I commend this bill to the House.
I thank the